matter of the King on the application of LJ Fairburn Son Ltd and others, and the Secretary of State for Environment, Food and Rural Affairs.
Yes, thank you.
My Lords, my Lady, I appear on behalf of the Secretary of State, and I'm leading Mr. Westmoreland Smith and Mr. Welsh. My learned friend Mr. Birdling and Ms. Klimovich appear on behalf of the claimants. This is an appeal from the judgment of Mrs. Justice Hill in relation to the slaughter of poultry, as you will have seen. There is an appeal brought by the Secretary of State on the issue of interpretation, and there is a cross appeal in relation to the Article 1 of Protocol 1 issues that would arise on the assumption that we're right on interpretation of that.
Yes.
And we have taken to heart the helpful indication from the court yesterday.
Thank you.
A day was probably quite enough for this appeal, thank you very much. So we're going to do it in a day, and what I was proposing to do was simply to say what I have to say about everything, and then hand over to
I think it would be helpful.
in the usual way, rather than trying to cut it
absolutely.
out.
Yes.
So that's what I was proposing to do. I was not proposing to introduce the facts or the evidential basis on which the appeal arises, because neither party, I think, takes any particular issue with the very, very helpful summary in the learned judge's judgment.
Yes, what I think might be helpful is just a brief summary of what actually happens, what the forms are, you know, how the process is carried through, in particular in respect of what happens to the birds, because obviously from the point of condemnation, that's the right word, to the point of slaughter, some will die, and how actually, you know, there's a realization of what happens during that period.
My Lord, I think the best description of that, if I may say so, taken faithfully from the evidence that my clients produced, I hope for the assistance of the court, I can identify where those statements are, but is in the judge's judgment, page 103 of the core bundle, you may have it separately, paragraphs 18, probably through to the end of 32, but it's really, in relation to the question that my Lord has asked, it's really paragraphs 18 to 25.
Well, if you start, you have an EXD 188.
Yeah.
And that sets out, after, I think I've got it right, after the W check, the number of birds healthy and diseased.
I'm not sure that is, I think the W check comes later.
Oh, the W check comes later.
Well, there are various, I mean, perhaps it may be worth, I mean, those are the paragraphs in the judgment.
Yes.
But the evidence on which they're based starts, I think, with Mr. Hickman's statement, I think is in the core supplementary bundle, sorry, tab 17.
Yes.
And there's quite a lot of introductory material in there. And there's then a section starting at paragraph 19 on page 514, headed the process and the forms.
Yes.
And that starts, as you see, with what happens when someone suspects there's a duty on them to report.
Yes.
And there's an initial attendance by the Animal and Plant Health Authority Veterinary Inspector, the AFA VI, and that's the first of the forms you see in paragraph 20 on page 514.
That's the EXD01.
That's the EXD01, exactly.
And that says, I'm giving you this notice, and you're now subject to a whole raft of statutory restrictions.
Exactly.
You can't really do anything at that point.
Because it's a suspicion at that point.
Yes.
But the whole thing is sealed in a sense.
The whole thing is sealed, as I understand.
You can't sell them.
You can't sell them as a massive restriction.
Move anything.
Exactly.
Yeah.
That apply on the schedules to that order, the 2006 order, as I understand it. So there's a whole bunch of control from that point on, including in relation to sale and realisation of value and anything else. Then there is a process of testing.
Yes.
To check whether it's the initial suspicion is well-founded, ill-founded, or not.
Yes.
It goes off to a lab.
It goes off to a lab, comes back within 24 to 48 hours, it's hoped, and then there's a confirmation of disease, and there's a decision by the Chief Veterinary Officer, paragraph 24, to cull.
Yes.
So it's the culling. I mean, there is a question about what condemnation means, and given that that's kind of one of the alternatives on the issue of statutory interpretation, the fact that there's some doubt about precisely when that point is reached is of a little significance, but you'll see that there's then an EXD 16.
Yes.
Is
Notice
the
of
word,
intent.
I'm so sorry to interrupt you,
I'm
James.
so
Is the
sorry.
word condemn or condemnation actually used in the statute?
No,
So where does that come from?
I
That's
think it's just a shorthand that the parties
right,
have used.
okay.
Yes.
But in any event, you've got a notice
So
of intent.
first of all, first it's frozen,
Yes.
and then the notice of intent to slaughter is what actually the ED 16 is what initiates the what might be called the statutory process.
Yes.
I think there's an intermediary. I think you get the EXD1, which says there's a suspicion. Then you get the investigation and the result, and that either it's all clear, and then you get an EX5, which lifts the restrictions, or you get an EXD2, which imposes even more stringent conditions.
Maybe I'm being nodded at. My lord is right, of course.
And at that point, then it goes to a chief veterinary officer who makes a decision to cull, which is then notified, and that's the EXD 16
That's
notice of intent to slaughter.
It's a
And I
notice-
think that is what condemnation refers to as much as anything.
Yeah, I suppose. Well, there may be a combination of that and what then follows, which is the 188 form.
The 188 is much later. I mean, 188 is just before you do the culling, and it's all meant to take place in very quick
Right.
order.
But there is a
we know in some of these cases there was up to 2 weeks gap between the chief veterinary officer saying, "I've decided these have to be culled, and here's your EXD 16, which is the notice of intent to slaughter," and the actual culling beginning to take place, and the walkthrough and the EXD 188 takes place just before
Yeah.
I have to say this is not as cleanly dealt with, either in the judgment or the skeletons, as it might have been, and one has to dig through the evidence to try and put it all in order, but I did spend a bit of time doing that.
Well, my lord, apologies that you've had to take the trouble to do that. I mean, there's maybe at least a fuller explanation of the sequence, even though the O2 form that you mentioned isn't necessarily referred to even in this evidence. But there's a slightly fuller explanation in the paragraphs we're looking at. Culminating, as you say, in the 188, where you do the W and the walkthrough and all of that, and then there's evaluation stuff that happens thereafter, which is probably not so significant, which is actually calculated. But that's one source in there, and then you see how compensation is calculated from...
Well, sorry, could you just spend a bit of time on that too, I'm afraid? They say that what then happens, in order to calculate the amount of compensation, refer to all those forms. So the number of birds culled and the number of dead birds, as recorded in the ED 64, are added together. And the ED 64...
It's not explained in this witness statement. You have to go to Mr. Hickman's second witness statement,
Yes.
page 528,
Yes.
paragraph 3.
The record of on-farm culling of stock, my lord, yes.
So by the time the culling takes place, inevitably there will be a significant number of birds that have died between the EXD01 and indeed the EXD188 and the culling. And somehow that number is recorded and calculated. In other words, it is as my lord said, the EXD64 sets out somehow or other the number of birds which have died before culling, and then the number of birds. And
We've got that at page 560, an example, 559.
yes,
Yes,
and then you go back to calculate the amount of compensation that has to be paid using the EXD188 as the sort of percentage proxy, as I understand it.
Well, that's my understanding, because they can't...
You don't do it.
Individual birds in the shed of 1,000 birds,
exactly.
whatever it may be.
So that's the proxy that's used to calculate the number of healthy birds at the date of the culling.
That's my understanding.
Yeah.
And just to complete the evidential references, if I may, there's a bit of reference as well to the policy and how it all works and the change of policy. We've seen reference to the EXD 64 in Hickman 2 on page 528, and then there's a bit of additional material in relation to the 188 form and in relation to the various other forms, including the reference to EXD 64 in the statement of Mr. Soldan.
Yes.
See page 534. Or really starting under background, but there's a short bit in relation to that explaining some more about the forms and some more about the calculation of compensation.
Yeah.
But that much advances that picture.
Yeah. Right, thank you.
So there are, in summary, ratcheting up controls from the first moment of suspicion.
Yes.
And there is likely to be, almost inevitably perhaps, but with varying lengths, but there is likely to be some hiatus between the initial restriction being imposed in the 01 form, the greater restrictions being imposed in the 02 form. There's probably going to be a hiatus between those two things and the next form, which is the order for cull, form 65, and then there's a bit of a delay. I think the evidence is about 2 weeks max between that and the actual cull itself. And during that period, or any of those periods, it follows that there will be some healthy birds at the beginning and there will be more that will die.
Yeah.
For obvious reasons, because this is a virulent disease and the legislative scheme in effect permits the slaughter of both healthy and diseased birds for the purpose of disease control and welfare. Well, I'm sorry you had to go through the
No, thank you.
trial of chasing down the evidence on that, but that I think is the relevant summary of it. I was proposing to go straight into the issue of interpretation, if I may.
Yes.
And in relation to the correct approach to interpreting provisions, and this obviously is a provision, the one we're really worried about is in primary legislation. It's in the schedule to the Animal Health Act of 1981, with irrelevant amendments having been made to that in 2003, as we'll see in a moment. But the two Supreme Court cases I just wanted to remind you of, they're both now, I'm sure, very well known to the court, but just to remind you of the relevant bits. The O case, which is Lord Hodge, in tab 23, I don't know if you're working with paper or electronically, it looks like all paper perhaps.
We're all paper.
Which I think is it 25, the first bundle? 25?
Yes, it is.
Yeah, so 23, end of the first. It's set up in a slightly odd way with the statutory provisions kind of halfway through the authorities bundle. Anyway, so tab 23 is the project registration of children's British citizens.
Yes.
And the relevant bits, the context doesn't really matter, but the relevant bits for present purposes are in the judgment of Lord Hodge. In particular, paragraphs 29, 30 and 31. Can I just invite the court to cast a quick eye down those paragraphs? Of course, will fit, I think, under that. You'll see they will sit under the heading analysis just above paragraph 26. But you'll see that the Supreme Court went out of their way, para 28. So it was opportune to say something about the process of statutory interpretation. So that's what they're doing. They're giving some general guidance about the process.
Yes.
Can I invite you to read 20 through to the end of 31? I don't think any of this will come as a great surprise to the court, but it's a helpful collation.
So as I understand it, Sir James, no one's relying on any external aids to interpretation in this case, so we can sort of
We can forget about that. Perhaps 30 is less important. It's 29 and 31, perhaps.
Yes.
So you'll see that the aim and object of the exercise starts with seeking the meaning of the words used. It's a refocus on the actual words used in their statutory context. And in context means in the context of the section itself and in the context of other relevant provisions in the legislative scheme within which they sit. And I should add that consistently with that approach, the judge noted as one of the principles governing interpretation that the search was for the natural and ordinary meaning of the words that Parliament has chosen to use, and she cited at paragraph 42, Roman 3 of the judgment, the Lambeth case for that purpose. But the message is that the words are the primary source by which meaning is ascertained, and the reason for that is the one given by Lord Hodge in paragraph 29, just above the letter D on page 866. There is an important constitutional reason for having regard primarily to the statutory context of Lord Nichols explained, and it's effectively that citizens should be able to understand the effect of the legislative provisions that govern them. And it's that focus on the primary source and the reason for that that leads, in effect, to the statement of principle in the first sentence of paragraph 31.
When you say the natural and ordinary meaning, that's not the end of the inquiry. That's where you start. You
Well, my lord, that's where you start. But
and what I think was Lord Culmer said is you quite often end there as well. But that's not the totality of the inquiry, obviously.
That's not the totality of the inquiry. But the message, if anything, from Lord Hodge is to re-put the centrality of focus on the words used by Parliament. That's really the significance of this passage.
The problem with these authorities is one can find authority for almost any proposition. You can find authority for the proposition, but the proper place to start is understanding the statutory context.
My lord, certainly, but one can find authority for most propositions, but these are Supreme Court authorities, and they've obviously taken the view that it's about time everyone refocused on actually how you're meant to go about doing the exercise. And the message here is look at the words, look at the words, look at the words, if I can put it in the vernacular. That's the thing I take from it. But my lord, of course, is right, and also purpose, which I come to in a moment. But I mean, sometimes one has words that genuinely do need to be quite seriously massaged. And I remember once doing a case about the meaning of embryo in contexts in which you didn't have male and female genes feeding into the process because you had cloning. And the question was whether that fell entirely outside all the scheme of control under the Human Fertilisation and Embryology Authority.
That's Quinta Valley.
That was Quinta Valley, and they adopted a pretty purposive approach to the question of what the word embryo meant, and expanded it to include that. But the focus is on the words. The other Supreme Court authority, to similar effect, but re-emphasising purpose, giving credence to my lord's point my lord put to me, is Lord Sales in the Packard decision, 2023, and that's in 2 tabs further on in tab 25, which may be the last of the authorities in that first bundle. And the relevant paragraphs for present purposes are on page 921, paragraph 40, and you'll see that the citation from Lord Nichols is the same bit of Lord Nichols that Lord Hodge relied on in paragraph 40.
Yes.
And then there is reference to some pretty well-known cases, including Rossendale and Quinta Valley, the one we've just been talking about, and the famous statement by Lord Bingham, paragraph 8 of Quinta Valley, emphasising purpose, and perhaps making the point that my Lord Justice Nugee was putting to me.
Well, I think I had more in mind what Lord Mance said,
Yeah.
that in some areas the notion of words having a natural meaning is not always very helpful, and the place to start is the legislative purpose and scheme. So, in a way, it doesn't matter where you start, as long as you
take into account all that you need to.
Yes.
My Lord, yes. I'm perfectly content with that. And there's no part of my case to suggest that legislative purpose, context, looking for mischief of the legislation and so on, is not a critical part of the analysis. Of course it is.
What you hope is that the natural and ordinary meaning of the words march with your identification of the statutory purpose and context, in which case,
my Lord, of course,
that's the answer. But
in which case, that's the answer. And sometimes one has an analytical task of a little delicacy, at least, in analysing precisely what the purpose was in relation to a particular part of a particular bit of a provision within a broader statutory scheme, which may be a little bit closer to our game. And in relation to that, if you are in that position of delicacy and a little uncertainty as to precisely how that particular highly focused bit was meant to work, then it may be that the natural words, the sway that is to be given to the natural words, elevates a little. But this is exercise that I thought would be very familiar. Anyway, I thought it was right to take you at least to those two Supreme Court authorities which emphasise the correct approach. I wanted then to come to the key points as we see them to be on interpretation, and I start with the meaning, as we say, natural and ordinary meaning of the words of the relevant provision. If you go into the second of the bundle of authorities, you can put that first one away. If you go to the second of the bundle of authorities, you go to tab 36. You'll find the key provisions on page, it's a bit confusing here because there's lots of different numbering on the bottom of the page. I'm going to go on the numbering in the middle of the page.
Right.
Pages, because that corresponds to the electronic number, if ever you get to that. It's 1286. And you should have paragraph 5 of Schedule 3 to the 1981 Act there.
Yes.
And the really relevant bit for present purposes is 5.2. Just so you note, it's a little confusing the way it's come out of whichever search engine has printed this, but there's an earlier version which still applies in Scotland on page 1285. We don't need to be unduly concerned with that, because as I understand it, even though by the second hole punch on page 1286 it says extent England, Wales and Scotland, in fact the position is that the change that was made by one capital A only applies to England and Wales and doesn't apply to Scotland. You know that why they've repeated, or why they put the different bits in. So you just need to be a bit careful about that. Nothing turns on it, but I was just a little bit puzzled when reading that as to how.
Well,
why.
that's in very tiny print at the top of each version of paragraph 5. There's the top of the first version.
Yes, it says Scotland and on the bottom of the page England and Wales.
Yeah.
Exactly so, but if you go below it,
You have to read it very carefully.
and there's another little bit just by the second hole punch on page 1286, which rather suggests that the entirety of the paragraph 5 in brackets applies to all three, and it doesn't. We've been back to that.
Which is not right.
To that amending order. It doesn't matter, but just for completeness. But so the words we're focusing on are in sub 2 of 5. I'm sure the court will have seen and considered, and I wanted to make essentially 5 short points about the meaning of that provision. It deals, as you can see, in effect in 2 halves, with both the duty to pay compensation, shall pay compensation, then the question for what, and the answer to that is absolutely clear and no one disputes it, for poultry other than diseased poultry. That's the first half. And the second half, which shall be the value of the bird immediately before it was slaughtered. It's got those 2 elements to it. But in relation to that provision, 5 points. Firstly, the duty, and indeed the correlative right, compensation, applies only to healthy and not to diseased birds. If the poultry are diseased at the time of slaughter, they fall outside the duty. That's the first half. And note in that respect that sub 3 of para 5, unlike the imposition of the duty that we're considering in 2, provides a discretion for a minister to prescribe compensation or a compensation scheme, in accordance with the scale approved by the Treasury, for diseased poultry. slaughtered under this paragraph. So the first point is that it applies to healthy and not diseased birds. Secondly, the duty attaches to those healthy birds that are actually slaughtered. See the reference in the first half, in other words in the duty half, to shall for poultry other than diseased poultry slaughtered under this paragraph. So it attaches to healthy birds that are actually slaughtered. And that is important because it does not state that the duty attaches to birds caused to be slaughtered. I'll come back to that under the submission I'm going to make on the legislative context. It doesn't say that. It says slaughtered, not caused to be slaughtered. Nor does it say that the duty attaches to birds that are in fact slaughtered, but that are healthy at the time or date when the birds are caused to be slaughtered, irrespective of whether they're diseased at the point of slaughter. Doesn't say that either. So the reference point of the duty and its operation is actual slaughter. The bird can't be diseased at that point. Otherwise it falls outside the statutory duty to pay compensation. That's the second point. The third point is that where the duty applies, the value to be paid under the compensation scheme is the value of the bird immediately before slaughter. So there is one point in time, effectively, that governs both the content of the duty and the valuation, and that is the point of or immediately before slaughter. And of course, if you set it up in that way, you create coincidence or alignment or coherence, if you will, between the duty and the value to be paid. And we submit that immediately before means what it says. It's not the value at some earlier point in time, for example, when it's caused to be slaughtered. Still less is it the value of a bird which used to be healthy but was diseased at the point of slaughter. That would involve, we submit, paying for a diseased bird, and it's crystal clear that the duty only attaches to healthy birds that are slaughtered and not diseased at the point of slaughter. If the bird becomes diseased between order and actual slaughter, the compensation duty doesn't apply. The result otherwise would be that you'd have to pay the value for diseased birds, even though they're not within the scope of the duty.
What is the value of a diseased bird?
Well, that was the other point I was going to make, which is that it's hard to see how the diseased bird has any value at the point of slaughter if it is diseased.
Presumably you can't do anything with them.
You can't do anything with them. But that is quite an important point, because that is why you would need and why you could have a provision to ascribe value at some point prior to the animal becoming diseased. If you see what I mean, you could set the thing up in that way. And indeed, if you just flick back in the statutory scheme...
Is this the fourth point?
This is still the third point.
Still the third point.
Still the third point. I'm so sorry, there were more than one. B and C. But they're quite important points in their own rights, but I'm focusing on the immediately before bit. But if you go back to 1.4, you'll see this is all about cattle plague in cattle. Page 1279. And you will see that the minister shall cause to be slaughtered all animals affected with cattle plague. That's 1. 2 is dealing with healthy animals that have to be slaughtered for control purposes or welfare purposes. So they've been in the same shed, stable, hurdle, flocked and so on. And he can, if it's necessary for preventing the spreading, cause that animal to be slaughtered as well. So you kill the diseased ones and you kill the healthy ones as well for the purpose of preventing the spread. And 3 is to similar effect. And then you get to the provision of compensation. Shall for animals slaughtered under this paragraph pay compensation as follows. where the animal slaughtered was affected with cattle plague, in other words, within 1, the compensation should be 1/2 its value, and this is the important bit, immediately before it became so affected. That goes to my Lord Justice Nugee's question. In relation to cattle, they've set the value by reference to a healthy animal prior to it becoming infected. And in that case, it's £20. And in every other case, in other words, in the case of healthy animals which are slaughtered, it's double that effectively, it's £40. But you'll see the wording that could be used if that was the intention.
And that's not the only example in the statute.
It isn't.
I think 2.3 is similar.
2.3 is very similar, and we've got numerous other examples that we've set out and we'll come to. And so if they wanted to do it in that way, you can't say, well, there's a diseased bird at the point of slaughter, it's got no value once it's diseased. And if you're going to kill the diseased ones and you're going to provide compensation in a different way, you have to, as it were, put it back to the point before it got infected.
But your point is, this is a technique that's available to the draftsman and used by the draftsman in these other provisions.
Exactly so.
And not used in these provisions.
And not used in this one. Yep. That's exactly the one.
So sometimes with diseased animals you get half the value before it was affected. Sometimes you get the full value for foot and mouth disease. You say for birds you don't get anything.
Yeah. And I say you don't get anything, that's the statutory intention for good or ill. You don't get anything because there are these techniques, as my lady just put to me, and they haven't used it. And you can't say, well, take the value of the diseased bird at the date of slaughter because it's diseased and it hasn't got any value. So you have to use the notional technique of, as it were, throwing yourself back to a point before it got diseased. So that is the end of the third point, mercifully. That's the third point. And I'm
just before you move on,
yes.
Do we take it that the original version of what was para 5 is what still applies in Scotland?
Yeah.
On page 1285.
Yeah.
So that was all introduced at the same time, and presumably by the same draftsperson as the paragraphs that, well, for example, paragraph 3, which deals with foot and mouth disease and so on.
Yes. As you can see from the commencement provisions.
I see.
Amongst other things, but yes. So when there are changes, they normally come in the form of capital A's.
Yes.
And the notes will give you which legislative provision made the change. So yes. So as originally enacted, you go to what is currently the law in Scotland, if you see what I mean, without the 1A and 5. Yes. Enough on the third proposition. Fourth proposition. The value is the value of the bird. I'm going back to paragraph sub 2 of 5. Shall for poultry other than diseased poultry slaughtered under this paragraph pay compensation which shall be the value of the bird immediately before it's slaughtered. And that must be a reference to the bird to which the duty to pay compensation applies. In other words, the value of a healthy bird at the point of slaughter or immediately before it's slaughtered, and not a diseased bird. It is not the value of some other notional bird which might have been healthy at some earlier point, because otherwise you create a disconnect between the nature of the duty and the nature of the value. If that had been the intention, you'd have to replace, as I think my learned friend Skeleton implicitly, if not expressly recognises, you'd have in effect to replace the with a. It does not say the value of a bird, which may be diseased when slaughtered, but was a healthy bird at some earlier point in time. So it's the value of the underlined bird. That's the fourth point. The fifth point is that if Parliament had intended to set up the scheme so that birds that so that A, the duty attached to birds that used to be healthy when they were caused to be slaughtered but became diseased before slaughter, and B, then the value that is taken is the value at that earlier point in time. If that had been the parliamentary intention, which is effectively my learned friend's case and has to be, then we submit that the wording could not have been and would not have been in the form of sub 2. Why is that? It is because it would have to have been made clear that poultry other than diseased poultry in the duty shaping first half of sub 2 was not a reference to healthy poultry when actually slaughtered, but was a reference to poultry other than diseased poultry fixed. In other words, health or disease fixed at the time at which they were caused to be slaughtered. And Parliament could easily have done that. Indeed, not merely do you have the point about compensation by reference to other provisions that I made earlier, but it's also evident from, for example, paragraph 1.1 in Schedule 3, back at page 1279, that Parliament was well alive to the difference between actual slaughter and something caused to be slaughtered. Look at the wording of 1.1. The minister shall cause to be slaughtered. And the same in 2.1. And the same indeed in 5.1.
I think it's in all of
It's in all of them.
paragraphs.
But there is somewhere, I'll come to it when we get to context, there's also, it's clear that they distinguish between, in at least one of these provisions, between a liability to be slaughtered and actual slaughter.
Was that section? Was one of the sections?
I'll come to it. It's a slightly different part of my notes, but it's the same point.
Yeah.
If they wanted to do, it's the point my lady put to me, if they wanted to do cause to be slaughtered things, then the weaponry was to hand. So the first key flaw in my learned friend's argument, going back to 5.2, is that it is necessary to imply words, and the words would have to be caused to be, before slaughtered in the first half of the duty setting provision in 5.2. And that's,
I don't think this affects the force of the point you're making, but actually I have a doubt whether the minister ever does cause to be slaughtered birds that get diseased, which are healthy at the time of condemnation, when the EXD 16 is served, but get diseased and die, and then the evidence is that with this particular strain, birds that are diseased die very quickly, within hours sometimes. So are never slaughtered. I don't think those birds are caused to be slaughtered.
well, my lord, that may reinforce the point.
They're undoubtedly condemned.
Yeah.
The chief veterinary officer has made a decision that they should be culled. But if by the time the people with the gas actually turn up, half of them are dead, he doesn't cause those to be slaughtered. They've died of disease.
Oh, well, I see the force of that, but if anything, it strengthens the point.
Well, it does slightly.
Because
But I just quibble with the idea that what 5.1 is doing is identifying a class of birds which are actually caused to be slaughtered. Sorry, it is doing that, but that's not actually what the respondent wants. What the respondent wants, as I understand it, is not just to be paid for birds that are culled but diseased when they're culled, but birds that were healthy when condemned and then died before being culled.
That's exactly what it was.
Well, I don't think the words caused to be slaughtered actually do that. What he wants is healthy birds condemned, which were healthy at the point of condemnation.
Oh, well, yes, I see the force of that. I mean, and rather than I'm accused of underselling a point of interpretation, but you're right. It doesn't help my learned friend, even on the assumption that cause to be slaughtered is apt to do the thing he wants. I respectfully submit that would be very, very difficult, because they had the weaponry to hand, they've got that concept in there if they thought that was what applied, and you would have to imply it into that duty-creating bit of paragraph 5 sub 2. It's not just an interpretation thing, particularly given the use. You've actually got to imply the words in, and not merely implication with all the difficulties that has, the limited circumstances in which you can actually imply. You need super purposive considerations, such as those in Quinta Valle, to enable you to do that. But it's not merely implication, but it's implication to introduce, back to my lady's point, it's implication to introduce the very concept, or a very concept, that Parliament has deliberately used elsewhere, e.g. 112151 and so on. It's evident, therefore, we submit that actual slaughter is what is referred to. And unless that is done, in other words, unless you imply those words, you also have to interpret the bird as being a reference to a notional or hypothetical bird that was healthy but then became diseased after slaughter. But not merely that. My learned friend also has to imply words into the second half of 5.2, in other words, the valuation bit. And that is, if anything, even more complicated. The value on his case is not value immediately before they're slaughtered, because they're diseased at that point, ex hypothesis, having been healthy when caused to be slaughtered on this hypothesis. So you need something like an implication of words like at the point when caused to be slaughtered. You've got to set a different time frame and take it right back to whatever point it is that creates the effect. But it would have to be something like at the point when caused to be slaughtered. So it isn't even exactly the same implication in the second half as in the first, which is why I say it's even more difficult. And all of this, we submit, is miles away from the actual wording which is used, which clearly, we say, sets the duty by reference to birds actually slaughtered and fixes the point of value at the point, entirely coherently with that duty creating first half, sets the value at the second half at the point immediately before the actual slaughter. And as I say, if that had been the intention, the tools were to hand, and it has to be said, they were not used.
So does it follow, Sir James, from your submissions that the judge asked and answered the wrong question? Because she seems to have thought that the question was, when does the right to compensation accrue? Whereas your submissions are, paragraph 5 is dealing with what you get compensation for and how much you get.
Yeah.
And it has nothing to do with when the right accrues.
No, exactly so. Exactly so. So that's what we say. Those are the 5 short points on the wording. And I've covered much of what I want to say on context, legislative context already, but just to pull them together, my basic submission is that in this schedule, and indeed in the Act itself, more generally, Parliament has carefully distinguished between concepts that are relevant to 5.2. We've seen in particular paragraph 1 of Schedule 3, and you will recall within 1.4, when Parliament wanted to tie the compensation calculation to a point of time prior to, immediately before it was slaughtered. Not merely did it do so, but it probably had to do so, because the value of a diseased animal infected with one of the diseases this schedule is dealing with would be nil, or likely to be nil. But in any event, it used specific language when it wanted to create the different effect, and the language used in 1.4 is immediately before it became so affected. Entirely logical, entirely understandable, but there's the wording. And we've given you in paragraph 14 of our skeleton other examples in a similar vein. I won't go through them. You can trace them through, and they're all to the same ilk. I did just want to pick up 34, because that was the provision go back to page 1274, middle of the page if you would. That was the provision I was struggling to remember when I was having my exchange with my lady a minute ago. Look at 34.1. Minister may, notwithstanding anything in this Act, reserve for observation and treatment an animal liable to be slaughtered. So that's the kind of alternative to caused. Liable to be slaughtered under this Act at his direction, but subject to payment of compensation by him in a case of actual slaughter. So same point. What is being done there is to distinguish between a liability to slaughter and actual slaughter. Same punchline. They were well aware that if they were going to go for some different concept, My learned friend's case, it's at the point at which, part of the point at which there was an instruction to cull or a cause to be slaughtered or allowable to be slaughtered. That has to be his case, and it doesn't work because the Act clearly distinguishes between those two concepts, and we know which one is used in 5.2. It is actual slaughter. So Parliament is quite capable of drawing those distinctions, and when it so intended, it did so. So that is the relevant part of the statutory context we submit. That's all I wanted to say about that. So far as purpose is concerned, broader purpose is concerned, so we've got wording, context, and now purpose. The statute I submit in relevant part, in paragraph 5, particularly 5.2, is clear that compensation is not to be paid for diseased birds. It is only to be paid for healthy birds, and that is no doubt because, doesn't matter if it's entirely clear which it is and no one quibbles with it, but that is no doubt because that whether a bird becomes diseased is no doubt intimately linked to the nature of the business, its biosecurity and all of that. And there's a policy choice in effect for Parliament about who bears the risk.
Why is a distinction drawn, as on your submission it is, between cases like foot and mouth, where the farmer gets paid the full value of a diseased sheep at the value it was before it was affected, and cases like cattle plague, where you get half the value of what it was, and cases like poultry, where you get nothing?
Well, I'm not sure I know the answer to that, but it is clear that that's how Parliament has set it up. I mean, one can see that broadly similar biosecurity and so on considerations might apply to each, but the Parliament has deliberately set it up in those different ways. Precisely why, I suspect, is probably lost in the mists of time, but I'll see if there's any obvious answer.
I mean, it makes it quite difficult. One often feels this when being invited to look at the statutory purpose, to know quite what was in Parliament's mind, as to why it took a particular policy choice one way or another.
Oh, yes.
Your submission is
it's clear that that's what they did. And
the language is clear, and it's not for us to second guess the policy of Parliament.
Language is clear, and moreover, all of those choices are within the margin for a state to decide upon. And these are ultimately judgments which weigh up risk and value and how much biosecurity could be expected to cut in and so on. And these are policy judgments for Parliament to make, whether they were economic.
Well, I find it very difficult to assess, because I don't have the material, as to whether, if a flock has a few diseased birds, it is really something where the risk ought morally to be borne by the farmer if he loses his entire flock, which, as the figures showed, can be a hugely a disadvantageous process for chicken farmers, or whether it's something that morally it ought to be borne by the state as a whole. It's just bad luck. So when you refer to it depends on the level of biosecurity and so on, I find it very difficult to know to what extent we can really make an assessment.
Well, I'm not inviting you to make assessments or findings of fact. That's why I preface the submission with no doubt.
Yes.
I mean, those things will feed into part of it, and other things will also feed in, like how much money can be expected to flow from one thing or another thing. One simply doesn't know. But my fundamental submission is that these are, I will use the word moral, it's not far off that. These are legislative policy choices for Parliament to make. And we're dealing with quite a narrow thing here, because there is a compensation scheme, and what we're actually arguing about is the purposive difference, if you will, between one which sets it at the point of actual slaughter and one which sets it at some earlier point, which may be a matter of days, it may be a matter of weeks, it may be a matter of whatever it is, and that may be a greater or lesser impact. But what you'd have to do if you're going to build a purposive case would be to say it's so clear that that's a crazy thing, if you interpret it in the way that Edie suggests, that should influence the way you approach what would otherwise appear to be the clear and natural meaning of the words. And my submission is that you don't get anywhere near that once you realise, amongst other things, the fineness of the distinction between the two rival cases of interpretation. There's quite a bit of debate, and one sees it reflected in the judgment, about whether there would be perverse incentives unless it's fixed earlier than slaughter. But I respectfully submit that those sorts of arguments about perverse incentives are almost impossible to resolve and probably exist in the mind of lawyers anyway. I mean, the aim of the regime is to set effective protection to try to control the spread of disease and for welfare purposes. And that may involve killing both healthy birds and diseased birds for the purpose of containment or welfare reasons. And in any event, to the extent that there did need to be the requisite controls to enable that broad purpose to be effective, those exist. They exist in the way in which a sequence of forms is set out and the various duties under the 2006 Act are set up so that suspicions have to be reported by the farmer, then there is provision for restrictions to apply from that earlier point, ratcheting up and so on. And we also know Article 20 of the 2006 order that you'll have seen reference to, that there is a duty to ensure that birds that are to be killed are killed without delay.
Can we just look at that?
That's Article 20 of the 2006 order. It's tab 42, page 1342, which is my note.
We're not being asked to decide whether there was any delay. It's something touched on in the evidence,
Yeah,
and in the pre-action protocol, but it's not an issue for us.
It isn't an issue for you, nor is it, mercifully, is an issue for you, whether you'll see references to the change of policy.
Yes.
In effect, pushing out 24 hours to 48 was the substantive effect of that. And we're not being asked whether that was ultra vires or not. In other words, whether that fell within the concept of without delay for the purpose
But that happened in the next year.
That happened in 2022, I think. It doesn't affect the issue of statutory interpretation that we're dealing with. The only reason for referring you to this provision here is to illustrate that the broad purpose is given effect by these various other provisions, so as to make it clear that you don't need to arrive at a strained meaning to the natural meaning that I've submitted applies to 5.2 in order to give effect to a statutory purpose where that statutory purpose argument would, as I say, have to depend upon the difference between the rival interpretations. In other words, doing the compensation from notionally point of cause to be culled if that's the right thing rather than actual slaughter.
One of the respondents' complaints is that there was delay, which they, I think, say was culpable delay, which you deny, and hence that you might have a flock of 30,000, most of which were healthy at the point of condemnation, but because of a delay, by the time they came to be culled, most of them were already dead, and that's unfair. That's what's said against you, I think.
My lord, yes, and my submission is that that doesn't alter the meaning and effect of Article 5, sub 2, which is very, very clear in its terms and in its effect. And there are a series of safeguards built into the order to try to make sure that this process happens. Now, of course, Parliament can be taken to understand that in times of crisis, delays may be slightly longer or slightly less long. And if
the impact was very much more severe in this year than it
much more severe in 2020 because of the scale of the outbreak. And so in those circumstances, it's unsurprising that. But my understanding of the evidence is that the difference or the length of time that it actually took was no more than about 2 weeks at the maximum, even in that time of crisis.
Yes, but the policy aim was 2 days.
The policy aim was 2 days, and to get it done as quickly as possible. And as I say, there is a statutory revision that says you've got to do it without delay. So Parliament specifically took that into account and made the provision that it did in the order.
Would that give rise to an action for breach of statutory
Well, that would be a
That's not a question before us, but
Yeah, I mean, there are 2 questions built into that single question as well, which is whether or not you could JR someone on an immediate and urgent basis to say you need to get on with this because the compensation is affected, so there's a public law remedy that is sought.
And
There would be a
apply for
separate
interim
question.
relief and a mandatory interim order.
I
so-
suppose you'd have to apply and do that and
Do
say
it now.
otherwise irreparable damage. At least in
Yeah.
theory that would open up a public law claim because there's a duty imposed by the statute to do it without delay.
I imagine that if you were on the other end of such an application, you might say, well, we'd love to, but we can't. It's just physically impossible. We don't have the manpower.
My lord, and that would bolster, I'm sure that would be the defence, I'm sure I would be sent in to say precisely that. But that would rather bolster the idea that Parliament can be taken to understand that without delay has, despite its imperative terms, has to have a degree of flexibility because there are only so many resources available to government to deal with spikes and crises.
Well, that could be an answer. It could be an answer to a mandatory injunction, but not an answer to a claim for damages.
Well, query, there would be a separate question
Yes.
about whether or not in principle breach of
Well,
statutory
it's
duties
quite difficult to get.
sounded in
damages,
damages,
breach
and
of
that would be
statutory
quite difficult
duties.
again. I'm sure I'd be sent in to say no.
Well, you start by saying this is not enacted for the benefit of the farmers, but for the benefit
Yes.
of the community as a whole.
But we
Whatever.
know the principles that
Yes.
govern those. It's the question of statutory interpretation as to whether or not Parliament intended to confer a right.
And I say, I think it's fortunate we're not being asked.
You're not being asked to decide that either. I mean, the core point for present purposes is that if there is unfairness, in inverted commas, caused by that delay, that there are already bits within the statutory scheme that tend to that and that focus on that.
I suppose you might also say that if Parliament envisaged that it was going to happen within a couple of days, Parliament might not have thought it worth drawing a distinction between the date at which you're condemned and the date at which you're slaughtered, because they wouldn't have appreciated it.
But there'd be a significant difference.
Significant difference.
Well, my lord, it might have done that, or it might have said in the context of poultry, yeah, well, it can,
Even a day makes a
it can
difference.
explode and move very quickly.
Yes.
But we ultimately have to make a judgment call, a legislative policy call, in this case in the primary legislation, because this is all, what we're arguing about is in 5.2 of primary. We've got to make a judgment about whether you get more for a cow than a chicken and how it all works, whether it should be point of slaughter or some earlier point, to be set a value at the point at which it was healthy notionally, which involves reinventing a kind of hypothetical wheel and taking time back. But you remember my fundamental point on interpretation is they had that weaponry. The weaponry was right in front of their face. It's evident that the draftsman was well alive to those differences between concepts. Actual slaughter, liable to slaughter or cause to be slaughtered, compensation set by reference to a notionally healthy animal, which even though it's now diseased, all of that is there. We don't have to invent this as a hypothetical thing that the clever parliamentary draftsman can be taken to have understood, because it's there on the face. And that is, I respectfully submit, a very powerful point.
Might it be said also that when making the order and imposing a duty to act without delay, I mean, it would have been open to the lawmaker to have imposed a duty to act within a specific time, and that choice wasn't made.
Yes, could have done that. Could have done that. So, my lords, my ladies, that's what we say about interpretation. I wanted to pick up one thing which is of some importance to the judge's reasoning, my learned friend's argument, which is what I call the Horner line of authority. And I say at the outset that for our part, we are not deniers of the principle. What we are, however, are advocates for circumspection in its application and some care in its application. And I do respectfully submit that this canon of interpretation, like perhaps many of the canons of interpretation that one sees listed in Benyon and other books, that this canon of interpretation does need to be treated, as Lord Neuberger invited everyone to do, it does need to be treated as a as a mechanism for assistance, as he put it, treated as guidelines rather than railway lines, servants rather than masters, they remain of real value if they're treated as guidelines to illuminate and help rather than to constrain and inhibit. I'm quoting from paras 57 to 60 of the Cusack case.
Was that a Horner? It wasn't a Horner.
It wasn't quite, it was two different schemes of compensation. I mean, it's quite hard to know quite what a Horner type case is because it covers a variety of different things. But the first point I make is a bit careful because it's a canon of interpretation, it isn't a hard and fast rule. See for that purpose Cusack, tab 16, page 5, 6, 8 to 9. Don't invite you to read it now, but I've summarised the Lord Neuberger approach, and I respectfully submit that is right as a general matter. Second thing, as a general matter, the principled underpinning of the principle, however expressed, is that, I respectfully submit, identified by Lord Reid, R-E-I-D, in Westminster Bank. Can I invite you just to go back into the first bundle of authorities, the way the statute revisions go back to the first bundle of authorities, and I want tab 10, page 363.
Is this the principle that Parliament can interfere with people's rights, but needs to use clear language?
Well, it's a bit that, but I'm trying to identify the underpinning for even that principle.
Well, it's all part of what we now call the principle of legality.
It is, very similar to that. But the principled underpinning for that as well, that has a slightly different one, which is you can't override rights by using general words.
Yes.
And override is the critical bit, because you can't just turn up and say my convention rights might have been interfered with. You have to establish it to be a breach. That's a long line of authority that deals with that. The point I was after from Lord Reid in Westminster on page 384, and this was about, just to put you in the context before I come to the bit, this case was about a refusal of planning permission on the basis that if the bank was given permission to do its development in a particular place, that might have impact on a power that existed in the local authority to widen highways under a different statutory scheme. And of course, if they widened, the reason the issue was sharp was because if they widened the highways and done a delineation thing under that highways legislation, they'd have had to have paid compensation. So they turned down permission on a basis which didn't include compensation. That was the context for it, but the bit I really wanted was between C and D on page 384 going on the bottom numbers. I entirely accept the principle, that's the colonial sugar Horner principle, as you see set out in B. I entirely accept the principle. It flows from the fact that Parliament seldom intends to do that, and therefore before attributing such an intention to Parliament, we should be sure that's what was really intended. And so, in essence, this canon of interpretation is, in truth, underpinned by the idea, it's a relative idea that underpins it. The more radical the thing that is being done on one interpretation is, the less likely it is that Parliament would have intended it, and if it was going to be taken to have intended it, you need some clear words. But it's a relative principle. It isn't a principle that applies, and this is perhaps our respectful prime criticism of the judge, it isn't a principle that applies in a kind of hard-edged way, so that whenever you are dealing with any part of a scheme in legislation that interferes with property rights and or any part of a compensation scheme for that, it isn't a principle that says if you're simply in that enormously broad territory, all that a claimant has to do is to establish an arguable position on interpretation to win. So we respectfully submit that this is a canon of interpretation. We're not denying it, but we say careful in its application. It's about legislative clarity that one would expect depending upon the seriousness or radicality or radical nature or otherwise of what is actually being done. And that requires you to look at the particular interpretive issue that divides the parties when you're making that judgment.
But in a way, it all goes back to the passage from Horner that's cited by the judge in paragraph 43, and it just goes back to the construction of the Act.
It goes back
You
to
shouldn't construe the Act as interfering with or injuring persons' rights without compensation unless one is obliged so to construe it.
Yes.
So it all goes back to what do the words mean.
It all goes back to what the words mean, and that is our respectful submission about the totality of the case law.
Yeah.
Because every time you look at a case, you go, oh, well, that's entirely understandable they reached that view in that context for that reason. So you have, and indeed the principle as expressed in order, you will recall, was, as my lady's just cited, was without compensation.
Yeah.
So if you interfere with property rights, you take property rights away and you pay nothing, take Dekeezer, or Dekeezer, I'm not going to go back to the little panic joke in whether we need an act.
De Kaiser.
Well, there was a big debate, and we're going to have to go back to the joke the Lord Panic made in the case about whether we need an act to leave the European Union. Whichever pronunciation it is, the hotel case involved, as you will recall, the MOD or the Army or whoever it was, taking over a hotel for the purposes of billeting, in effect, and then saying we don't have to do anything, we just take it over, we're not going to pay any compensation.
Well, I thought they'd say they'd pay ex gratia.
Well, yeah, whatever, but didn't quite do it, and it wasn't quite the amount they wanted, I think, if there had been a proper compensation scheme in place. And they didn't use that. But anyway, if it's without compensation, and it's a radical interference with property rights or taking it away, then it's entirely understandable that should be the position. So you take the position in Horner itself. In Horner itself, which you'll recall was about the market.
Spitalfields.
Yes, could a market happen outside the relevant square in the surrounding streets of the relevant square, and paving acts were being relied upon by the local authority, in effect to take away the previously established, by grant, the previously established right to have a market on certain days. And what the court decided, unsurprisingly perhaps, was, well, you can read the two together. So that on market days and during market hours, the market right sits there and you can't interfere with that, because otherwise you'd in effect be taking away a right without compensation. But there's still some play for the legislation in the Paving Act, because the local authority can make sure that the highways are not obstructed outside those market hours, or for other reasons. You'd have a circus or whatever else it may be. And the same applied, for example, in colonial sugar. Takes the facts of colonial sugar, where you had a previously established ownership right, I think by limitation, previously established ownership right over a wharf or a pier, and there was then a consolidating act that says all rights that used to be vested in the commissioners on X date are to be vested in the commissioners, and the question of interpretation was whether a provision of that kind in effect overrode or extinguished, brackets, without compensation, the previously established right, property right, to own the wharf, established in whatever way it was established, and the answer was no. But those are simply illustrative of the nature of the principle, which is a relative one. And in those cases, entirely understandable why the principle should apply, because they were taking away actual property rights without any compensation at all. Westminster Bank, which we still have open perhaps, Westminster Bank was a slightly different one for the reason I've described. You could see the result perhaps going on the merits either way, because the question, ultimately it might be thought, was whether or not you could use planning permission to achieve an effect, brackets, without compensation, that you couldn't achieve, and exercising that power on the basis of a prospective future exercise of a power which, if exercised, would require compensation. You could see someone saying, well, you're effectively doing a swerve to get round the requirement to pay compensation were you to delineate in this way. You're just going to the prior point of planning permission saying, well, we're going to do it that way. And so you could see the merits going either way. In fact, the House of Lords decided no, because planning permission never normally attracted compensation, there was nothing wrong with that. and as long as it was a legitimate public law reason for refusing planning, then that was the end of that. You didn't have to give compensation. But all of these are illustrative of their own facts, as my lady rightly characterised it. It just comes back to what the relevant legislative provisions actually mean. And the reason I emphasise relative goes back to a point I made earlier on. As you will recall, I said, well, I submitted that when you're judging the seriousness of the impact, you do actually have to have regard to the tightness of the interpretive issue you're actually looking at. And here we've got a scheme which allows animals to be killed for good public interest reasons, but does in fact provide a scheme of compensation. And what we're arguing about is the difference between setting that valuing process under that scheme by reference to a slightly earlier date or a slightly later date. So I respectfully submit that we've actually got a compensation scheme here, so we're not squarely within order. And if you're doing and recognising the principle as a relative principle, I do respectfully submit those sorts of judgments are pure legislative policy. They don't sound with anything like the same degree as cases in which you take away property without any compensation at all. And one can see variations on that theme through the case law. I mean, British American Tobacco is in your bundle, which was about stopping tobacco companies using their trademarks and logos on the front of packets of cigarettes because they were designed to pull punters in, and the government decided they didn't want that as a mechanism of control. So it was said, well, there we are. That's a breach, amongst other things, of a common law principle, in effect, the Horner principle, of taking away property without compensation. And the relative approach is evident from that decision also. So I respectfully submit you need to keep the issue actually tight. You need to recognise its relevant and relative proposition of principle. And what it does not do, and certainly does not do in context, is, as I said earlier, it does not lead to the position which the judge appears to have taken, which is that if only someone can identify a potential, we say it isn't properly arguable anyway, but a potentially arguable point of interpretation, they win. That, we respectfully submit, is on no view the correct application of the broad principle, of course, the existence of which we don't deny. We say the devil is in the application of it.
Because the judge's job is to decide what the words mean, not what they arguably mean.
Exactly so.
Yes, but if you do have two rival interpretations, then this sort of consideration, which you don't lightly assume Parliament to have intended to take away property without proper compensation, can be a relevant factor in deciding between two alternative interpretations.
It certainly can. We don't deny the existence of the principle or its application in certain circumstances. One just has to be careful about not turning it into a hard-edged rule that simply says identify an arguable interpretation and you win.
Yes.
It depends upon what is being done. What's the nature of the thing? How radical is it? And because it goes back to the Lord Reed underpinning of principle, which is the more radical the thing, the less likely it is that Parliament would have intended it, ergo you would need clear words to ascribe that intention.
That's all part of the judge's job of deciding what the words mean.
It is.
And there isn't a two-stage thing where you say, well, is it ambiguous? And if it's ambiguous, then this principle comes in. You say, what do the words mean? And in deciding what the words mean, I take into account the argument that they take away property without compensation.
Exactly so. So there's no disagreement between my lady and my lord.
No.
Well, I think there might be, because I think
Yes. I didn't want to create discord, but there was.
I thought your submission was that actually there is only one available interpretation of these words. The one, when the judge says they're both reasonable interpretations, that's an error. There just isn't a reason.
My lord, that is my primary case. Because even if the principle applies, it applies in circumstances where you can get to a certain threshold of respectability, if I can put it neutrally, in terms of the argument the other way. So if it is clear...
Well, I thought that was what your 5 points were. So there is actually only one meaning.
That is my primary submission.
Yes.
But if you get into the principle, I do not accept that principle simply says you just need to identify ambiguity. You can take it into account as part and parcel of the thing, which is why I respectfully suggested that
So your argument is this point just doesn't arise because the language here is so clear.
I say it doesn't arise, and if it does, if you do wish to take into account the Horner principle, you need to exercise caution with its application and to recognise that it is not a principle. Really, the submissions that we made are encapsulated in our skeleton at 23 and 24. It's really a plea to the application of the principle, recognising it relative, recognising the principles underpinning for it. That's all we say. So there are primary and alternative arguments. The primary one is it's too clear anywhere, or it's clear enough anywhere, however you apply the principle. In any event, careful with what the principle actually means.
Yes.
ECHR. I can take that
ECHR.
shortly because it's not my bag to open, but
Please, I think it's better doing it that way.
It arises if we're right on interpretation. I said earlier that there are plenty of cases that say you can't just turn up and say convention rights are in play, ergo the principle of legality operates and so on. That is a principle that operates only if, applying ordinary canons of interpretation, you would have incompatibility effectively, where they override, so there's got to be a breach otherwise. And the same applies under Section 3 of the Human Rights Act. The principle that you can interpret so long as the interpretation is possible, that strong interpretive rule in Section 3, only applies if on ordinary approach to interpretation there would be incompatibility. See, amongst other ones, Lord Wolfe in Poplar Housing. So it arises if we're right on interpretation. There are effectively two parts to the debate, and almost every debate one ever has about Article 1 of Protocol 1 divides into two parts.
I'm sorry.
I'm so sorry, my lord.
You said the same applies under Section 3, as if there are two exercises going on, but isn't there only the Section 3 exercise? I mean, isn't this question, this is primary legislation of the UK Parliament. We can only depart from what we would otherwise interpret it as in reliance on Section 3, isn't it?
Well, I think that's right. I don't think any plea has been made, despite some references to the similarity between the Horner principle and the principle of legality. It was really the principle of legality that I was nodding at. But my lord is right, strictly, we're on Section 3 or bust territory.
Yeah.
And so Section 3, you can only use the possible if otherwise the thing would be actually be incompatible. Because there's many times when people turn up and say, well, do this interpretation, but by the way, you can stretch it a bit because we've got convention rights in the frame.
Yeah.
And there needs to be some rigour with that for Section 3 purposes and also for the principle of legality. Because the principle of legality, if you were there, and that normally applies when you're dealing with general words, it's a restraint on the interpretation of general words in legislation. If you are in the territory of principle of legality, Lord Hoffman's famous exposition of it included critically the word overridden. So it's to the same effect. You can't just turn up and say my convention rights might have been interfered with a bit. You have to show they would have been overridden, in other words, breached.
Where does Lord Hoffman say that? It's a very familiar passage.
It's Sims.
Sims.
Yeah, it's Sims. That's principle of legality. But we haven't got general words here, we have very specific words, which is why my lord is right that it's Section 3 or nothing. So the two basic parts of the analysis under A1P1 are deprivation or control of use, and then fair balance. And my submission, as you know, is that the judge was right for the reason she gave on this part of her judgment at least. This provision that we are focusing on, 5.2, is part of an overall scheme of control, as you've seen, a scheme of control of animals, in our case poultry, that might be infected with infectious diseases, a scheme of control that exists for good public interest reasons, and a scheme of control that has a myriad constituent parts that you've seen in the statutory scheme as a whole. So there's a duty to report if there's suspicious circumstances, there are duties that cut in if there are suspicious circumstances, there are controls that apply at that stage, there's then a right to cull or a duty to cull in certain circumstances, and then there are compensation provisions. So you've got a whole scheme which is a control of use, and that's a control of use in relation to the animals and their farming. That is the scheme. The fact that property is or may be taken away or forfeited as part of that scheme does not prevent that characterisation. And that is clearly established by, for example, and early doors in the Strasbourg jurisprudence, the Agassi case. That was the one about the Krugerrands being forfeited when they were imported for breach of export or import controls. I'm not going to turn these cases up, but I'll give you the references if I may. 26, tab 26, page 994, see especially paragraph 51 of Agassi. And in Agassi, as I say, there was forfeiture, but nevertheless the scheme was described as a control of use scheme for the purpose of A1B1. British American Tobacco, see in particular paragraphs 97 to 100, and the reference there is tab 18, 18 at page 658. Again, I've described the facts of British American Tobacco. Might be thought that the trademarks associated with the packaging design have been completely taken away because they could no longer be used, but the court applied a broader approach so that you could have a control of use characterisation even if, in a real sense, some part of someone's property was actively destroyed or taken away. And then two cases to do with culling, which were the cases that the learned judge relied upon as establishing a consistent line of Strasbourg authority in favour of control of use rather than deprivation. They are the Bio Dardenne case, see for that purpose paras 47 to 49, tab 33, page 1232, should get you to those paragraphs, and a case called Chagnon, where you have a French version and an English version, but the English version is at tab 31, page 1180, and that should get you to paragraph 36. And in both of those cases, both involving culling, control of use. So it might be thought smack on point. My learned friend, I think, says that the Bio Dardenne case was dependent upon not a deprivation decision, was dependent upon the meat from the slaughtered animals remaining the property of the applicants. And our respectful answer to that is that you don't get that from reading Chagnon and Bio Dardenne together. There's no indication, for example, in Chagnon that was part of a relevant legislative scheme. But the broader point is you look at control of use versus deprivation by doing what might be called a stand-back analysis, looking at the scheme as a whole and the fact that some part of it might involve taking or depriving or killing or whatever it may be, property, matters not to the overall position. So the first submission is it's control of use rather than deprivation. The second submission is it may not matter anyway much, and it may not matter anyway much because even in deprivation cases, it is possible to have deprivation without compensation, and in truth the Strasbourg analysis is more a spectrum type analysis rather than a binary line type analysis. How serious is the interference, therefore how weighty is the justification. But you can have deprivation cases where there is no scheme for compensation, but rather than delving into those slightly more turbid waters, the real reason it doesn't matter much is because you have actually got a scheme of compensation here. And all we're arguing about is the precise mechanics of how that compensation scheme works. So we are not, on that view, into what might be described as more weighty justification territory.
If one stands back, actually taking somebody's bird and killing it clearly does deprive them of it. So why is that not a deprivation?
Well, there's no more, because you have to alter the telescope. You have to look at it from the other end of the telescope. You have to see the broader statutory scheme within which it sits. You could make exactly the same point about the Krugerrands in Agassi. The Krugerrands in Agassi were forfeited.
Yes.
They weren't just frozen, they were forfeited. They were taken away by the state. and nevertheless it was characterised as control of use. And the same in relation to the two directly applicable cases. In both of those cases, there was culling. So one can see the argument that says, with deprivation, if you kill, you must deprive.
Well, just as a matter of ordinary language, you clearly do deprive the poultry farmer. When you cull the birds, you've deprived them of them.
Well, yes, I'm not going to demur as a matter of language. The question is, what is the approach to the relevant ECHR question? And that allows for the possibility that you could, whether linguistically or otherwise, describe something as a deprivation. You kill it, you pretty clearly deprive. But that doesn't matter. You look at the scheme more broadly overall. If my lord's strict logic was right, you'd be in trouble explaining away the two culling cases.
But also, maybe that would only apply to the birds you actually culled. It wouldn't apply to birds that were healthy when condemned and then died. You haven't taken those away. It's the disease which has taken those away.
Yes.
You've clearly controlled their use. Because once you've served the EXD1, you can't do anything with them.
Yeah.
And that's why they end up dying. But you haven't killed them.
Well, that is true. But as I say, I respectfully submit that for all the interest and kind of philosophical teasing of this issue, I mean, in the end, it probably doesn't matter very much. Because we have here got a scheme of compensation. The question is how it works and how it applies.
Yes, I see.
And as I say, and also because even if you have a deprivation scheme, there are some circumstances, it might be thought a bit like British American tobacco, in relation to which it doesn't really matter, because you couldn't possibly afford to pay billions and billions of pounds for the purpose of saying you can't use your trademark.
But I think the judge thought it did make a difference. I think she thought, is it deprivation or control of use? If it's deprivation, then there is an infringement of A1P1, but because it's control of use, there isn't. But you say that's not right.
I say it's not as simple as that. It's not as straightforward as that. There have been many cases in which there has been deprivation, depending on how narrowly or tightly you look at that idea, in which they've self-evidently held that it's a control of use, both of the culling cases you relied upon and so on. So I do positively submit this is properly to be characterised as a control of use for all the legal consequences that then flow from that. But it's not perhaps worth spending too much time on it, because ultimately here we have a scheme of compensation, and you can have deprivation without compensation in certain circumstances. It just goes to the weight of justification. It's a bit like the principle that we were discussing earlier based on Horner and its underpinning. The more radical the interference, the more that may be required by way of justification. That's not a stunning principle or a new one. And although they do try and analyse things in terms of control of use or deprivation, in those cases where there's no compensation, you can see why they might do that.
Well, in a sense, they have to do that because of the terms of
they've got to put it into one or other of the bits.
Yeah.
I would guess. So fair balance then, and I respectfully submit here that again the case law is pretty clear. If you're dealing with a context like this, you are in territory in which the state at the international level is accorded a very significant margin in how it sets up schemes of compensation, what the levels of compensation should be, the circumstances in which compensation is payable and all of that. That is broad margin territory at the international level, and that is evident from cases like Chagnon itself. If you go to Chagnon, you go to pretty much the last paragraph in the judgment. It's the margin that determines that the fair balance was okay, even though they're only getting 75% of value rather than 100% of value. And one sees that from all those nationalisation of shipbuilder cases in the old days. It's a territory where there are big, broad margins. Exactly the same principled underpinning for margin applies at the domestic level for those reasons, and also because under our constitutional arrangements, particular respect is to be accorded to legislative policy judgments made by Parliament. And here the balances are being struck by Parliament in primary legislation. So that's at the top of the judicial respect for the legislative body decision making. So we do submit that manifestly without reasonable foundation is is probably the right approach. But as Lord Reid, EE, famously pointed out in the SC case, as you will recall, manifestly without reasonable foundation is really just a description of the breadth of the margin, or of the degree of respect that is to be accorded to the legislature. And so it doesn't really matter what label you put on it, what matters is the breadth. And here we respectfully submit that there is obviously broad margin, particularly when analysing the question which confronts you, which is, do you set up the compensation scheme on our case by paying in accordance with what we submit as the right interpretation of 5.2, or do you pay compensation on the basis that Melanie Friend's interpretation is right? That's quite a narrow distinction.
Do you say the margin is affected by whether, using the terminology of the article, whether you're in the first paragraph or the second paragraph, whether deprivation or control of use, or do you say the margin is the same in either event?
I say the margin is the same in either event, but that margin itself is to some extent relative.
Yes, yes.
If that's not too complicated a way of
No,
looking at it.
yeah.
And so if you had a more serious interference, even if the margin applied, that would probably shrink it a bit.
Yes.
If that makes sense.
No.
But there isn't a direct, there doesn't seem in the case law, I think, to be a direct correlation between those two.
Yeah.
But that is how it would work in principle.
Well, yeah.
And my submissions, therefore,
Lord Reid tried to steer us away from hard lines.
he tried to steer us away from hard lines. I mean, he did. There are a series of cases, because no doubt, as you will understand, the government quite likes the phrase manifestly without reasonable foundation.
Yes.
It smells a bit of rationality, which the government quite likes as well. So we were quite keen to preserve that wording, and it is wording that is used in Strasbourg.
Yes.
Lots of the time under A1P1, but also when you're dealing with judgments about social security and so on, which is where it often comes up. So although he was keen to make sure that everyone understood that it was just language that described the margin, there sometimes is a debate about whether that's precisely the right way of describing it. So I respectfully submit there isn't a great deal of need, again, to go into that. We submit manifestly without reasonable foundation is the right way of looking at it, but even if that's not the right precise description, it's big broad margin for obvious reasons, because it's been recognised as big broad margin in directly applicable case law like Chagnon, and because it's A1P1 fair balance and legislative judgments by the state and all of that, and it's broad in our domestic context because these are judgments that are being made by Parliament in primary legislation. And here, therefore, there was compensation, a compensation scheme for the cull, and there's nothing unfair or outside the margin in Parliament deciding that the compensation scheme was to be paid only in relation to animals healthy at the point of slaughter and by reference to value at that time. Putting it as the condemnation point isn't the only fair way of doing that. At least perhaps because at the time of slaughter, diseased birds have no value. And indeed at the condemnation point, it may not be possible to say which birds are or will become diseased. And ultimately, these are all big, broad judgments for Parliament to consider and to make. And I respectfully submit that there's nothing unreasonable or outside the margin in the judgments they have made. So those are my submissions on fair balance and the way in which the initial issue of characterisation works, unless I can insist further.
Suppose we were against you on that, and we thought there was a breach of A1P1. What are the consequences?
Well, then you would have to see whether or not it was possible to interpret the language of 5.2.
This is the Section 3 strong interpretive obligation. Would it be possible, or would you say it's
My respectful submission is not. And
nobody's asked for a declaration of incompatibility.
Nobody's asked for a Section 4 declaration, but you'll be aware again that, not sure the case law is all in the bundle, but it's very well known, it's Gaydon and Mendoza and all of that.
It goes with the grain of the legislation.
Well, it goes with the grain, but it's also got two different bits to it. One of them is how far away from an ordinary meaning are you actually going, and are you trespassing into territory which is effectively legislative rather than judicial? And as part of that question, secondly, there is a slightly broader constitutional angle, which is if there is a change to be made, is it right for that change to be made by Parliament or the courts? But ultimately, it's that line between judicial interpretation on the one hand and judicial legislation, brackets not acceptable, on the other.
And your submission?
My submission is that the language is so clear here that you couldn't possibly do that. You will be going strongly against the grain, and you would be, in effect, inventing, by insertion of concepts that Parliament has self-evidently chosen not to use, in question. And that is not an acceptable process of interpretation. That is too close to the legislative line.
It's really all tied up with your first point.
It is.
That the interpretation really drives the answer.
It is.
That if we thought, as the judge thought, that there are two reasonably available interpretations, then we can adopt the one, if we thought there was a controversial A1P1, which would prevent there being an incompatibility.
Well, if you're asking that question in Section 3 terms, the answer to that is yes. Yeah. It depends on whether it's possible. And that's a strong tool, as the courts have consistently made clear, and I don't seek to deny. Yeah. It goes to the clarity of what you think the correct interpretive position is.
Thank you.
Anything else? No, thank you very much. Yes, Mr. Bradley.
My Lord, I propose to advance submissions under 6 heads. The first, which without straying into the detailed submissions I'll come on to make, will be to set out my stall on what I say paragraph 5 of Schedule 3 means. And I'll explain, I hope, while I agree with Sir James that there is a clear interpretation of that paragraph on the face of the provision. It's just not the one for which Sir James contends. So that's the starting point. And it's important to do so up front, of course, because that will anchor the discussion of the context, and also when I come on to later, the Horner principle, because Sir James, I think quite unfairly, uncharacteristically unfairly, criticised the judge for going straight to the Horner principle and then reasoning backwards from that. And that's not what the judge did at all, and that's not what I invite the court to do. I say you look at the provisions, the construction as I say it is, arguably as Sir James says it is, and the Horner principle is quite a strong tool that points you towards which one is the correct construction. I'll come on to that. Then my second head, and I can keep this relatively brief in light of what Sir James has already shown you, is to address the key context about avian influenza and its management. And as my Lord Justice Nugee observed, there is some factual dispute between the parties about what actually happened on the ground. That's not for this court. What I'm going to do is show you what the regulations set out. So the restrictions that are imposed on keepers when they're imposed and what their effect is. What wasn't in dispute below, and you'll see from the evidence there was some we said, they said about when particular visits took place. What's material and what wasn't in dispute is that there is a difference, and a quite significant difference, in the number of birds for which compensation was payable, depending on which of these constructions you adopt. And we set that out, I think uncontroversially, in an annex to our skeleton below, which you'll find at the core bundle behind at page 190. Again, that's all a matter, if we're right and you uphold the order of Mrs. Justice Hill, that will then have to be determined by the Secretary of State in a redetermination. So I raised that to explain why the facts and the factual disputes aren't dealt with in terms either by myself or by my learned friend. So that's my second head. Third, and again, without duplicating what Sir James has already shown you, address the statutory provisions concerning compensation, because common ground between my learned friend and I, unsurprisingly, that one doesn't just look at the words in isolation. Indeed, the authorities to which Sir James referred you very much warn you against tunnel vision in statutory interpretation. One looks at the statutory scheme as a whole. So I will show you that scheme as a whole. Then, and only then, do we reach the Horner principle, and I'll address that and explain why Sir James is wrong as a matter of principle and authority to say that it's a limited principle in the way that he suggested this morning. Then fifth, I'll draw those heads together and make submissions as to why, on what one might call the orthodox or non-Human Rights Act construction, explain why Mrs. Justice Hill was correct to conclude that the construction was as the claimants below suggested it was, and therefore that the Secretary of State had failed correctly to discharge the obligation to pay compensation. And then finally deal with the cross-appeal, the Human Rights Act issues, the issues there, the battleground Sir James has set out quite clearly, so you'll then hear what I have to say about that, but the lines of argument at least are clear. So first, and centrally, what do the respondents say the proper construction of paragraph 5 of Schedule 3 is? Can I ask you please to turn that up? It's behind tab 36 of the Authorities Bundle at page 1286. First thing to note about this provision is it's a provision that confers a duty. Sorry, a provision that confers a power, rather. You'll see other provisions confer duties. This confers a discretion on the minister to cause certain animals to be slaughtered. And it doesn't do it in general terms. It does it in very specific and precise terms. So what it gives is a power for the minister to cause to be slaughtered diseased poultry. And as we'll come on to see, that's a defined term. So you've got diseased poultry. Then you've got suspected poultry. And then you get on to the general categories, but they're general categories that are quite precisely defined. Of any poultry the Secretary of State thinks should be slaughtered with a view to preventing the spread of Avianza or Newcastle disease. And then if you look at paragraph 1A, that's very broad.
Sorry, where were you saying that?
Sorry, that's paragraph 5. So 5.1 is...
Yes, you've got A, diseased or suspected. Then were you talking about B?
B is any poultry that have been in the same field pen.
Exactly, or otherwise in contact
otherwise
with.
Potentially exposed.
Yeah.
C, general, that's the general power. Think should be slaughtered with a view to preventing the spread.
But so you were categorising. So we have disease, we have suspected, we have the same field. That's B.
And then any poultry the Secretary of State should be slaughtered. And then 1A is expansive of C and makes clear that those poultry don't have to fall into any of those particular categories, just emphasising the breadth of it. So what those provisions do are setting out a schema as to when the Secretary of State has the power, and this is one of the key aspects when we come to see the Horner principle, is you don't assume that there's a power to do anything with someone else's property unless you've got clear authority. Well, the Secretary of State's got that, but it's conditional. Because what section 5.2 tells you is that the minister shall for poultry other than diseased poultry, and we'll come on to slaughtered under this paragraph, pay compensation, and it tells you what the value is. So, in other words...
Sorry, when you say it's conditional, sorry, I'm not following.
So there's an obligation, there's a discretion. So the Secretary of State has a power to cause those birds to be slaughtered.
Yes.
That's exercised at a particular point of time.
Yes.
So this is an answer to a question.
It's conditional on, I would have thought it's conditional on the poultry falling within A, B, C.
That's a definitional requirement.
Right.
And then the minister can cause those poultry to be slaughtered, but that has a consequence. So consequence condition might not be the correct way of framing it.
Okay.
But it carries, the exercise of that power carries a correlative duty. That might be the best way of expressing it. Which is to pay compensation, which is the value of the bird, immediately before it is to be slaughtered. And the language is, the language you see in 5.1 is the minister may cause to be slaughtered. The obvious explanation for that is it's not anticipated that the minister, or even necessarily the minister's officials, will be carrying out the cull. What the minister is requiring is that those birds be slaughtered. Then what you see, so the question, when does the Secretary of State cause an animal to be slaughtered? In my submission, that is when the minister makes the decision. The minister will know, and you don't have to hypothesize, you've got the facts of these particular cases, and that will inevitably be the situation, that the minister will be aware, because by the time the decisions will come on to see is being made, there are some birds in the flock that will have the disease. So the minister will know at the time that the official veterinarian is ordering the cull, that there are some birds that are diseased that he is causing to be slaughtered. There are some that are suspected that he is causing to be slaughtered on the basis that they are suspected poultry. And then there are some that fall into the other categories, if that's what he's doing. Of course, he doesn't have to do that. The minister could say, actually, all I'm going to do is order a cull of the diseased poultry. There is an identifiable, say there's a farm and there's a barn where all of the animals are diseased. I'm going to order a cull of the diseased poultry. Well, at that stage, the minister knows that's what I'm doing. What are my obligations for compensation? Well, actually, it's 3. Have I made an order? So there aren't. And cause to be slaughtered, therefore, to address an exchange that my Lord Justice Nugee had with my learned friend, it's not a factual inquiry that what's being referred to there. It's not suggesting that there's a question of causation. That would be the case if this was a provision that was dealing solely with compensation, if it was asking a factual question. But that's not what Section 1, which is where you find that language, appears. It's a section that's imposing a discretion. So what the minister is doing is, I mean, you know that this is what happens because it happens in fact. The farmer is told there's going to be a cull. At that point, the minister has made a decision to cause to be slaughtered animals falling within those particular categories. And I do say that must happen at the time that the decision is made, because it's not the case that the minister is saying, well, I'm going to cause to be slaughtered at some future point in time poultry that may or may not fall within one of these particular limbs. What the minister has got to do is got to say, well, what do I know? I know some of these are diseased, so I'm going to cause those to be culled. Some of these are suspected, I'm going to cause those to be culled, and some fall into the other categories, and I'm going to cause those to be culled. And if that wasn't the exercise that the minister was required to go through, the provision simply wouldn't be drafted the way it is. It would be structured differently, because you would have a general power to cull at the front, and then you would have this detailed schema down the line when you were talking about compensation, but it's not. That's not how it's structured. All of the distinctions occur, they're front-loaded, and they're dealing with the question of conferring the power to be culled. Then we look at subsection 3. Now, subsection 3, what that tells you is that the minister has a discretion to provide, to create a scheme of compensation for diseased poultry slaughtered under this paragraph. What there isn't, and what you don't see, is a discretion which is dealing with any of the other categories, i.e. suspected poultry caused to be slaughtered under this paragraph, or any of the others. And what that points to is, again, my contention for which I contend, and the reason for that is, when you have a category that says, at the outset, the minister can cull diseased or suspected poultry, Well, when you're culling, ordering, causing to be culled suspected poultry, it must be anticipated that some of those will actually be diseased. But what you're doing at that point is you're saying, well, actually, it's only the ones that you're killing because you know for sure. This is when you're talking about what Parliament's intention was and where the balance of risk was. This is what it's telling you. If the animal is diseased at the point the minister makes the decision, well, unless there's an order that's been made that gives you a right to compensation in respect of those animals, you get nothing. But if it's just suspected, i.e. if the minister's caused to be culled poultry other than diseased poultry, i.e. because it's just suspected, and Sir James used the term healthy, and I don't criticise him for that because that's a shorthand I used in my skeleton, but it's important that you focus on the fact that the distinction is between diseased and non-diseased, and that includes suspected here. So what work does the value of the bird do, and the reference to the value of the bird immediately before it was slaughtered? As Sir James, I think, agreed, is a reference to valuation. So that's what you have. That deals with reckoning the quantum of the compensation. So the reference to the value of the bird immediately before it was slaughtered is a reference to the metric by which the unit value of each condemned bird is to be reckoned. And that, in my submission, is the clear and unambiguous effect of that provision. And we'll come on to see why that is particularly clear when we come to see the rest of the statutory scheme. Because in the statute itself, not in the schedule, there's a scheme of how one deals with unit valuations. And there is a provision for arbitration in the event that there's a dispute about the unit value. So what that's telling you is the point at time in which you determine the valuation is the market value immediately before slaughter, not some other nominal value or value that's fixed. I mean, in practice, you will have seen from the evidence, there's a set of published tables that tell you what the unit value of the birds are. And this, to answer a question again that my Lord Justice Nugee raised with my learned friend, what is the value of a diseased bird? Well, in practice, the value of the diseased bird is obviously zero. And we know that in terms of birds that are condemned because they're diseased, you don't get any compensation. But you have a scheme that tells you what the unit values of the birds are for the purpose of valuation. That's the way this scheme works. I mean, practically speaking, it's not a causation question. You're not saying, could you practically sell these birds? And the answer in cases of biosecurity is probably not. Indeed, you see from the scheme of the order that the Secretary of State has put in place, that actually you can't do anything with these birds once the order has been made. So what's the market value of these birds? If it was a question of causation, the answer would be the value is zero, because there's absolutely no practical possibility of anybody doing anything with these birds, healthy, diseased or otherwise, once the order to cull has been made. So you're necessarily, the whole effect of the scheme the Secretary of State has put in place is that you are looking at the value of the bird before the order to cull has been put in place, because that's the point of time in which it has a value.
Sorry, can I just be sure I've understood that? You're saying that if you're looking at the actual market value of the birds at the time of slaughter, none of them, whether they're healthy or diseased, actually have a value because they're all subject to restrictions.
The scheme that my learned friend has put in place, and I'm sure that my learned friend doesn't suggest that it's ultra vires, is that they become the property of the Secretary of State, and they are disposed of. There's nothing the Secretary of State can do with them. They've got to be, as a matter of law, disposed of. So the market value is zero. They can't be sold in a market.
But are you saying that is because of the effect of the provisions, or is that because of the effect of the state of the bird?
It's the effect of the scheme.
Right, but a healthy bird, absent the effect of the provisions, would still have a value.
Well, all of the birds have a value. That's what one has. I mean, this is the point of the valuation table, is all birds have a value. It's just whether that value is realisable. I mean, even diseased birds would have some nominal value.
Why?
Well, because for whatever purpose you may want to sell them, I mean, it could be pennies, but there would be a nominal value for a diseased bird in terms of the value that the meat could be put to, or the feathers could be put to. That would be if we were getting into, if that was what the valuation inquiry required, obviously you would have evidence about that. And I'm not suggesting they would be particularly valuable, but the reason why they don't have any value is because the Secretary of State has imposed an order that says they have to be disposed of. That's not the reason why you don't get compensation for diseased birds. You don't get compensation for diseased birds because the statute tells you you don't.
I don't think anybody's arguing that I mean, you're arguing an extreme that, as I understand it, properly read, none of these birds have any value. So because none of the birds on this interpretation have any value, 5.2 is meaningless.
No, that's not, my Lord. What I'm saying is that it's not the proposition that my Lord Justice Nugee put to my learned friend was that the phrase "cause to be slaughtered" interjects effectively a causation question into the whether you get, or what birds you get compensation for inquiry. And I'm explaining one of the reasons why I say that can't be so. My primary reason for saying it can't be so is that which I said earlier, that actually it's about conferring a power. The power, what that's telling you is you have a power to cause these birds to be slaughtered. And what I'm saying is the way that the compensation power doesn't work or can't work is that can't mean it's actually only healthy birds that are actually in fact slaughtered that you get the compensation for. Because what the provision is telling you is it's birds that you've caused to be slaughtered. And also, sorry, I'm dealing with conflating two things at once. It's also about the unit value of the bird. And what I'm saying is the value immediately before it was slaughtered, that particular phrase, what that is telling you is that when you want to look at the unit value of the bird, you look to the value immediately before it was slaughtered. And what I say is that can't mean, as a matter of fact, when you go and have a look on a particular farm, what the value of those particular birds in those particular circumstances are. It means what's the objective value of birds of that type prior, in my submission, to the decision to commit them to slaughter. And
I think you also say the value of the bird of this type at the time of condemnation, on the assumption that it was then healthy, and on the hypothesis that it was healthy immediately before it was slaughtered, as you...
My Lord, yes. For everything other than diseased poultry, i.e. poultry that was... Yes, because what you've got, again, coming back to the schema, is the Minister can choose to condemn to be culled birds other than diseased poultry, and then if he does that, the obligation is to compensate at the value of the bird immediately before it was slaughtered. So again, yes, you assume that that is a bird that is valued as the tables say it is, because that's what it's telling you. It's saying that you're fixing a moment in time, you're fixing numbers. I mean, it's all designed to be practically workable, because the scheme that my learned friend suggested was, in effect, ignore all of those provisions that come before about categorising birds into diseased, suspected, other birds. Ignore all of that, and just assume the only thing that matters is what state the bird is in at the time, no matter how distant in the future from the decision to cull, what the state of the bird is. And if that was the scheme, we'll come on to see quite how detailed the scheme for controls are. If that was what was intended, A, you would have expected to say so and not to structure the provision the way they have. You've heard my submission on that. But 2, you'd expect a machinery for working out what are diseased and what aren't diseased in the regulations, and there aren't. What you've seen is some evidence, none of which actually deals with the point of cull, about how internally for their own purposes, the Secretary of State estimates that. None of that's in the regulations. None of that is, it's just a consequence in my submission. The way that that is worked out is a consequence of the Secretary of State's misinterpretation of this provision.
Is there anything saying that at the point of condemnation, there should be a count as to how many are diseased and how many are not diseased?
My Lord, we'll come on to that, because the keeper is obliged to keep a record of healthy, suspect, everything from the point of notification.
Well, that's right up until the point of calm.
Right up until the point of calm.
So that doesn't tell you when in that period the legislation contemplates a distinction is going to be made between diseased and non-diseased birds, because it could be at any point you've got the records.
Well, my Lord, I think I have to accept that, yes. Perhaps because Sir James took you to paragraph 1 of the schedule about cattle plague.
Just before you leave, what do you say about birds that have died between caused to be slaughtered and slaughtered?
So this again comes to that's effectively the causal question that my Lord Justice Nugee put to my learned friend. I say that the obligation to compensate does arise there, because the question again is, have you caused birds to be slaughtered?
Well, is that the question? If one just looks at 5.2, I mean, there is that question, which is the question I put to Sir James. Does the Minister cause to be slaughtered a bird that is condemned but actually dies before it is culled? And what I put to him, so I'll put it to you, is that as a matter of language, although the Minister has made the decision that bird should be killed, the Minister never kills or gets anybody to kill the bird. It's the disease that kills the bird.
I accept that. I accept that, my Lord. I accept that as a matter of language. And what I say is that
that's not what 5.1 is doing.
It's not what 5.1 is doing. And what 5.2 is doing is telling you, I mean, the language slaughtered under this paragraph, I see the force in what your Lordship's saying, and that suggests that it's only birds. So to use, it's not that extreme of an example, because it would have been what happened if we waited another couple of days and for some of these farms. The Secretary of State just delayed culling to the point where all of the birds had died naturally. Sir James would say...
There were one or two barns, I think, where that was the case.
Exactly, precisely. No compensation on Sir James's case, because none of them are slaughtered under this paragraph. And that's why I say it can't mean what Sir James said. Slaughtered under this paragraph means when the Minister has exercised the power to cause them to be slaughtered.
So what your submission seems to me to require is that cause to be is treated as being inserted before slaughtered in both line 1 and line 2 of paragraph 2. So in other words, shall for poultry other than diseased poultry caused to be slaughtered, which will be the value of the bird immediately before it was caused to be slaughtered. Is that the effect of what
that's the
your
effect,
submission?
my Lord, yes.
Right.
And I don't say that is Sir James would suggest that that's doing violence to the terms of the statute. And I say it's the opposite. It's making sense of the scheme where Parliament has conferred, again, discretion, and then it's dealt with compensation. And this comes into, I say, sharp relief when we get to, as we will, the Horner principle.
Can I just be sure I've understood? Because what my Lord put to you, I think, was that you effectively read in the words cause to be. Both in the first line of 5.2, caused to be slaughtered under this paragraph, I understand that entirely, and at the end of 5.2, immediately before it was slaughtered, immediately before it was caused to be slaughtered. I thought your case was that you identify the pool of compensatable birds at the date of condemnation. When it comes to valuation, you do look at the date of actual culling, because if there's been a change in the table between condemnation and culling, you get the later one.
I do accept that. And then
so you don't put cause to be before the
second slaughter.
But then again, you have to put something, because we have to cater on your case
yes.
for the birds that have died in this interval. Your whole complaint, as I put to Sir James, is they delayed so long that everybody died. So you have to produce a construction that captures birds that were healthy at the date of condemnation, and not only were those birds which had become diseased and were culled, but those birds, which I think was the majority of them in many cases, which had become diseased and then died.
So, my lord, you're right. And what I say is, I mean, slaughtered, the concession about the variation in valuation between the time of condemnation and slaughter actually may be, it doesn't arise on the facts here, but it may actually be a bad one. It's a concession I made, but the nub of my argument is that everything is referable to the exercise of the power. So slaughtered, and before it was slaughtered, are a shorthand for the minister exercising the power, because at the time this provision was put in place, it was envisaged that would be the same point in time. You have the exercise of a power, and then you have an obligation to pay compensation that's consequent upon it. And when one's talking about risk, the risk again comes from, it's internalised in those paragraphs about the exercise of the power. The minister takes the risk when they condemn suspected poultry or other poultry, because they could wait and see. The minister could wait and see. The minister could say, actually, I'm going to wait and see and leave these on the farm. I'm not going to impose controls. And then if they become diseased and the minister then exercises the power, well, obviously they don't have to compensate. So the risk allocation really is a question for the minister when exercising the power.
But sorry, going back to the final words, which shall be the value of the bird immediately before it was slaughtered. The value. Is it the value at that date? Is it the value at some other date?
So the value immediately before it was slaughtered is the value immediately before it was condemned to be culled. So that is, it's the value as of that date, the date the minister makes the decision.
Under one.
Under one, because that's the date of the expropriation.
So it's not. So you have to change immediately before it was slaughtered in some way. And I know you say, in answer to my lord, that you don't insert the word cause to be slaughtered, but if you just take the words immediately before it was slaughtered, it's difficult to see how those mean anything other than immediately before it was slaughtered.
The work that slaughtered is doing here is slaughtered as a shorthand for what is in effect an expropriation, because that's what 1 and 1A are telling you, is that when 1 and 1A are affected, you will have your rights in the chickens being taken away because they're going to be killed. So that's why the language slaughtered is used. If the language in 1 had said the minister may, if he thinks fit, cause to be expropriated, and then you had the language expropriated in subparagraph 2, the meaning would be clear. And that's what I say it does mean.
What about if language in 5.1 had said the minister may, if he thinks fit, slaughter? Then your argument wouldn't work, would it? I mean, because one of your points is, and I understand this entirely, is it's entirely out of the farmer's hands. As soon as he makes the notification, which he's obliged to do, I suspect on pain of criminal penalties, he notifies the ministry. The man from the ministry comes down, takes the sample, goes off to the laboratory, it comes back, yes, you've got the disease, and then from the moment at which the man from the ministry turns up on day 1, you're subject to a whole raft of... You effectively can't do anything with your birds. You've lost control at that point. And unless that's revoked, because it turns out there isn't any disease, that's it, really. But that's not the point at which they're slaughtered.
It's not.
It's not the point at which they're condemned. There's a little gap. It's not a very big gap. There's a little gap between the laboratory saying it's a positive test and you get the EX2, your notification of more restrictions, and then you get the chief veterinary officer said, we're going to cull the whole flock, and you get EX16.
And my lord, precisely so. I mean, the reason I quite rudely interrupted your lordship is because the forms are apt to mislead here, because we'll come on to see, I mean, we're dealing with my headline submission now, but we'll come on to see in the regulation that actually the point at which the condemnation must, as a matter of law, be ordered is in the regulations, and it's before that form is served. So the form is about notification. But actually, legally,
right.
there's an answer. There is a point of time that
You haven't reminded us you're setting out your stall, so I think, shall we we'll reserve any other questions until you come to the statute.
The reason I'm doing this up front is I accept, as I must, that I've got to identify a tenable construction. And I say when you look at, we'll come on to look at all of the
Yes.
statutory scheme in its entirety. But it's just to deal with Sir James's suggestion that the judge effectively went off on the wrong tangent by trying to reverse engineer a construction rather than actually looking at what the terms mean. But before I do go on, can I just ask your lordships to look at paragraph 1 of that schedule, which was about cattle plague.
Yes.
That's on page 1279. And what you see here in my submission is exactly the same structure and exactly the same approach. So it's consistent not with what Sir James says the construction ought to be, with what I say, because what you have, again, up front, and this is the focus of the provision, it's conferring, in the case of the first one here, a duty to cull, and then in 2 and 3, a discretion to cull. So again, you have categorization of animals, and then in 4, what you have is that compensation differs depending on which category you fall into. So it's entirely consistent, in my submission, with what I say the operation of this schedule is. You identify the source of the power that's been exercised to cull, and then you work out compensation by reference to that. As I say, Parliament could have done it a different way in all of these paragraphs. And it could have said, don't worry about this scheme that's dividing animals up into different categories. Just focus on what happens post-mortem, or what you can determine post-mortem. And if that was what would happen, if that was what was going to happen, well, first of all, as I said, you would expect a machinery for determining. I take my Lord Justice Nugee's point that you will have the farmer's record, that one can anticipate that DEFRA would not necessarily accept that that was accurately capturing all birds that were diseased, because of course farmers aren't going to know that definitively in all cases. Rather, what you can know, and what is knowable, is on what basis the Secretary of State ordered the cull.
But the Secretary of State doesn't know how many are diseased. The Secretary of State makes the decision, or his officer's chief veterinary officer makes the decision on the basis that the disease has been found in this barn, and I think, in those circumstances, whether the chickens in the barn are diseased themselves or not, I have to kill them all. And so he doesn't need to know whether they're diseased or not.
My Lord, he does have the power to do that, but what I say, and again I say this is clear from the scheme of the regulation, is the regulation tells, if your Lordship was right, then of course it would just say, you just have 1A, you can kill them whatever you want, but the legislation tells you actually you've got to turn your mind to are they diseased, suspected, or do they fall into one of those other categories? And they are discrete sources of power authorising the culling, that is the expropriation of these animals. So that the minister does have to turn their minds. The minister will know. The minister will be able to say, I am culling this number of chickens because they are diseased. That's a decision. That has a consequence. The consequence is you're not going to get compensation for those. You could challenge that decision if you're the farmer. You could judicially review the Secretary of State and say, that's not a reasonable decision, or you've committed some other public law error in reckoning that. But short of that, that's what the minister knows, and that's what you know as the farmer. In respect of all of the other chickens, not those that have been culled or condemned to cull because they are diseased, you will get compensation, and that is a known and knowable number at the point at which the decision is made. And if the construction is contrary to that, as Sir James says, you will inevitably, as was surveyed before, have farmers will be required. I mean, they will need DEFRA to be there immediately. Otherwise, their compensation, through no fault of their own, is going to be diminished. And you can imagine that this court will be called upon to superintend the exercise of Article 20 and without delay. And what that is, in my submission, is a strong pointer towards that not being what was intended. It being intended that compensation and the number of birds that were compensatable was known and knowable.
But Article 20 is a provision in delegated legislation, and we're looking at primary legislation. So can you use Article 20 to interpret primary legislation?
My lady, no.
Right.
You can't, in respect of this provision of secondary legislation, I accept that. It is at best contextual. The reason I raised that is that your ladyship asked a question of Sir James in exchange about whether Article 20, said Article 20 of course could have been framed as imposing a duty to cull within a particular period of time. So I say it could have, and indeed if Sir James was right, probably it would have. But your ladyship's quite right, as this is subsequent secondary legislation that counters this. The reason I'm drawing a distinction is, as we'll come to shortly, there is some secondary legislation that precedes the 1981 Act, which is still extant. And I do say, as a matter of principle, that is relevant context against which the draftsperson of the 1981 Act could be expected to be familiar. I'll come on to explain that shortly, but that's why I'm giving a roundabout answer to your ladyship's question.
You've taken us to paragraph 20 at some point, and I'm not asking you to do it now. You'll have to address the different wording in 4A and B, namely value immediately before it became so affected, and the value immediately before it was slaughtered. At some point, we'll need to deal with that. So
this is your lordship's on paragraph 1 now.
Paragraph 1, 4A, and
yes.
B.
So again, this is so. Paragraph 1, 4A. I'll deal with that immediately if your lordship has it open. And again, it's because the affected. It comes to the categorisation point. If your lordship looks at 1A, that the power relates to all animals affected with cattle plague.
Yes.
So what I say is, it's no surprise that when you look at the compensation provision, that it maps the power, the terms of the power. So affected with cattle plague, what that's telling you is if the basis for the cull was the power in subparagraph 1, then that's exactly the duty. That's the consequence. And in every other case, i.e. 2 or 3, where 2 or 3 is the source of the power, the discretion, that's the consequence. So the difference in language is explicable by the fact that the categorisation or the conferring of the power is framed in those terms. And then you see this in every one of these paragraphs. You'll have a paragraph that confers a power, and then the compensation provision will be referable to the power that's exercised, not, in my submission, by the factual situation as it turns out ex post.
I think it's more that the words, that an express distinction is drawn between value immediately before it became so affected, and I appreciate the use of the word affected, and B, immediately before it was slaughtered. So in other words, there is express provision made for the manner in which compensation is to be calculated. And there's an express reference back in 4A, and we don't see an express reference back in 5.2.
We don't. And here, we are dealing with a distinction in terms of compensation that is being drawn in the context of cattle plague. And I am not sure what the factual reason is for that distinction.
Right.
What I do say is that, in fact, no distinction is drawn in the case of avian influenza, because you have the tables, and you've seen, your lordship will see how that works when we get to it.
Yes.
So it doesn't affect the mechanics or the operation of the section, but it does tell you, I agree, something about the timing. So that, in a nutshell, is my setting out my stall.
Thank you.
But before, I'm so sorry, Mr. Laing, before you move on, can I just be clear in my own mind what your submission about paragraph 5, subparagraph 2 of Schedule 3 is, please? I think you're saying that words need to be read in before the first occasion on which the word slaughtered is used, and the words that should be read in are cause to be slaughtered. Is that right?
Yes.
Right, and I'm just not sure what your submission is about the second occasion on which slaughtered is used. Does something have to be read in, and if so, what?
So it would be the same. So it's
the same.
It's the same, and the reason, again, slaughtered here is, in my submission, in this provision, and indeed all of these provisions, a byword for expropriated. The power, the animal being taken away from you and put to death.
All right. Well, I now understand. I just wasn't clear when you were answering questions from.
I'm sorry, my lady. It is
Nugee and my Lord Justice Moylan, precisely what you say, but I've got it now.
That is entirely fairly my fault.
Thank you.
So thank you, my lady. My lord, I'm not sure if do you want me to make a start?
Please.
On? My next head is the key context, and Sir James has taken you to some of this, and I think in light of that, I can be quite short. Indeed, what I will do is I'll just take you to the order, because I think this is what's important, because this is what Parliament has done subsequently that tells you factually, and I appreciate, in light of my answer to my lady's question, this is perhaps more relevant to Article 1 of Protocol 1 than the statutory construction point, but it is important because it tells us what factually happens in the circumstance of avian influenza. So to start, this is behind tab 43 of the authorities bundle. The key provisions, as I think the court has, so I'll do this quickly, starts at Regulation 9, which is on page 1391. So there you have the mandatory immediate notification. So when you suspect that a bird may have avian influenza, you've got to make the notification. You've also, you'll see at 9.1b, take all reasonable steps to ensure the measures in Schedule 1 are complied with. We'll come on to see what they are in a minute. Then Regulation 10, what that tells you is if there's an inspector, when the inspector comes and they suspect avian influenza is present, they must issue the notice. That's mandatory. And then Section 12, again, a mandatory provision. Can I ask the court please to read Regulation 12?
I think it's Article 12, isn't it?
Article 12, I'm sorry, my ladyship's quite right.
Yes.
And then Article 13 to 16, just skim those, please. That those are further wide-reaching powers that are conferred on the Secretary of State.
Yes.
To reduce spread. Then Regulation 19, and this is one of the critical provisions. Article 19 says that once the Chief Veterinary Officer has confirmed that it has happened, the veterinary inspector must impose by notice measures in Schedule 2, and as we'll come to see, that means cull.
Yes.
So that's the point at time in which, as a matter of statutory duty, and then the answer to, obviously I accept, in answer to my ladyship's question, that you can't use the regulation to interpret the primary legislation. But what this does tell you factually is, because one of the points that Sir James makes is actually it's jolly difficult to identify the point at time at which the condemnation is made. Well, actually, in this context, factually it isn't, because the statute tells you there's an obligation on the Chief Veterinary Officer to do it.
Sorry. It's the obligation in Article 19.
19.2, so the Chief Veterinary Officer must, upon confirmation, impose the notice.
Well, the Chief Veterinary Officer confirms the
Yes.
existence of the virus, and it's then a veterinary inspector who gives
Yes,
the notice.
who gives the notice.
So it's the giving of a notice. This is the EXD2. It's the giving of the EXD2, which you say is the date of condemnation.
It might be. So in some of these cases it actually happened informally. So what happened is that the farmers were told, and you'll see this in the evidence, over the phone, they were told that they are to be culled. And that is equivalent to the service of the form. The service of the form doesn't have any magic in the statute. It's that once you're told that these measures are being imposed, you're subject to the obligations we're going to come on to discuss. Then we get to Regulation 20. So what's happened after that is the Chief Veterinary Officer has got the tests and has decided what to do. Again, in the language of the paragraph, is it just the diseased birds? Diseased birds I know a disease that I'm going to cull, or is it the birds that are also the birds that I suspect are diseased, or is it all of the birds? And then you get to paragraph 20, and that tells you that when you've made that decision, the birds that are to be killed, i.e. the birds that you have caused to be slaughtered, have to be killed without delay. So that's how this works with that piece of legislation.
That is a step between 19 and 20 that is the Minister acting under paragraph 5.
Quite so.
And I can't remember which form it is, but a form will be issued setting out or confirming the decision that whatever is set out in that notice has to be slaughtered.
That's what's meant to happen, my lord, yes, and that is what the Secretary of State's evidence about the process is.
Yes.
Your lordship has the point that it's not accepted that in fact happened in all of these cases because there was an emergency and things fell between the cracks. But yes, that's how it's meant to happen. So that is the point at which you will have, if you're the Secretary of State, a record of how many animals you're culling, which animals fall into which category, and therefore which, on my submission, are compensatable.
Yes.
Sorry.
No.
Central. It's 1 o'clock.
I was going to leave you with a question you could ask
Yes.
answer it to. You said that Article 19 is the date of condemnation when you give the notice, which should be given in paper but sometimes given over the phone, because the restrictions showed that they're going to be killed. But the restrictions are in Schedule 2, and Schedule 2 doesn't say they're all going to be killed. It says you have to cooperate with any that are going to be killed. But that doesn't seem to me, on the face of it. I don't want an answer.
Lordship is right. I'll come back to that after the adjournment.
Yes, thank you.
And the question I was going to ask was, you said the Secretary of State will then know how many are compensatable, and I want to know how the Secretary of State will then know in support of that submission.
The short answer, which I'll give you now, and I'll give you the detailed answer, is the Secretary of State will know, because the Secretary of State will know which power he's exercised in order to authorise the culling.
Well, can I just ask you to think over lunchtime about a different way of looking at it, which is that is it not possible to read paragraph 5 conferring a broad power on the Secretary of State to cause to be slaughtered birds in all the categories that are there described, and that the Secretary of State, as long as the Secretary of State knows in a broad way that there are suspected ones and ones in the same shed and ones that it's necessary to kill to prevent spread, the Secretary of State doesn't have to identify each head of poultry which falls into each category.
I'll address that after the adjournment too. The short point on statutory drafting, of course, is if that had been what Parliament had intended the Minister to do, it wouldn't have been drafted in the way it was. It would just have a broad power. But I will come back to that question after the adjournment, if I may.
And we're still doing all right time-wise?
I think so, my lord,
Good,
yes.
thank you. So 2 o'clock.
All right, thank you.